Hello, good afternoon if you're on the East Coast, and I guess good morning if you're way out west. Some of our friends may be out in Hawaii are still having their morning cup of coffee. You're listening into the Regulatory Outlook for Higher Education, which is a higher education webinar series offering from Thompson Coburn. We're a law firm, as some of you may know, here in the Midwest, based in St. Louis, have offices around the country. But I want to start out here just with some housekeeping really quickly as folks are still joining in. If you have any questions during this webcast, you can submit them through the Q&A widget there at the bottom of your screen. We're delighted for you to ask questions. We have allowed for some time at the end, and we're going to try to get to those. Given the nature of the topic, we're hopeful that we will have some questions and discussion around where things may be going in Washington, D.C. There's also a resource widget down there. We encourage you to download any materials that are available. I'll just offer now too, and I'll say this again, while there may not be a lot there, there are many, many links in today's presentation. That was by design to lots of materials that are out there and available online. And when you get the slides from the presentation, those will be active links, and you can get additional resources that way. You can find additional answers to some common technical questions in the help widget down at the bottom of your screen. And importantly, if you're an attorney, this webinar is CLE, Continuing Legal Education, accredited in California and Illinois for an hour and a half, or 1.5 hours of general CLE credit, and in Missouri for 1.8 hours. As I always like to joke, we give a little more credit in Missouri. 1.5 hours of general CLE in Texas is also pending. We award CLE based on attendance for the entire 90 minutes. So from the time to time during the presentation, you may be required to click a little pop-up screen just to confirm your continued engagement. Finally, I always say, and boy, I could not be any more sincere, there is a post-webinar survey. We are so grateful when folks take the time to fill that out. We do read all of your comments, and we always try to make each webinar prior better than the one before. So Thompson Coburn, I mentioned, is a law firm. It's a full-service firm, one of the big ones these days. I think we're getting close to 400 attorneys, actually. We are based here in St. Louis, which is where I'm physically sitting, but we have offices around the country, and some of our other presenters today actually are out of our D.C. office. Our higher ed practice, I'm the chair of it, and we provide legal counsel, compliance, and training services to a very wide range of colleges and universities, do a lot of different kinds of things. Here's a picture of the folks in the higher education practice looking our best, or as in my case, as good as it gets. And today, I mentioned this is part of our higher ed webinar series. It feels like it's been a long time since we've connected with you all, and I think that's because it has been. We took December off, and now we're at the end of January, so it's been almost a couple of months. But we are really midway through our 2020-2021 series. If you want to go back, we had some really nice presentations in the fall, and those are all available on demand and free on our website. You can see those up at the top. We're currently doing Regulatory Outlook for Higher Ed, and you can see we've got 3 more planned already on the calendar for the spring. We're going to talk about higher ed transactions next month. That's going to be a great presentation. We're going to have a guest presenter in with us and really talk about valuation and structure. There is so much merger and acquisition activity happening right now across all sectors of higher education. It's extremely interesting, and we hope you'll tune in. We're going to do one in March on closed school loan discharge, which is a lesser-known topic, but an important one, and how it plays into teach-outs of campuses and locations and can come up in the transactional context. And then we're going to bring back, last spring we did a session with a couple of our litigators where they talked about court decisions, important court decisions in the student dispute arena, and they've agreed to do that again in April. So we hope you tune in for that as well. We have 4 presenters for you total today. I'm going to do them in reverse order of when you're going to hear from them. Chris Murray is my longtime friend and colleague and partner. He's the chair of our lobbying and policy practice, sits in D.C. And Chris not only is the chair of our entire lobbying and policy practice, but really focuses on education. So spends a lot of time working with institutions K through 12 and post-secondary. And he's going to join us towards the end, and you may hear from him throughout, chiming in as well. But he's right in the middle of it all right now. Katie Wendell, counsel in our higher education practice. You all who tune in regularly will recognize her voice. Does a lot of work in lots of different areas, but in particular is focused a lot on state authorization and distance education. And we'll be talking about the sort of the future of the innovation and accreditation rulemaking and the stuff that came out of that, meaning distance ed and state authorization. And Scott Goldschmidt, the newest member of our team. Scott joined us the second week of March in 2020. So some of us have never seen him in person, but we're confident he exists out of his basement in Washington, D.C. The former Deputy General Counsel for Catholic University. Scott does a lot of work in a lot of areas as well, but with a particular focus these days on discrimination law, and is going to talk a little bit about Title IX and what we see upcoming in that arena. And then finally, like I said, this is Aaron Lacey, and I'm just so pleased that you all have taken the time and joined in today. We think we've got some pretty interesting stuff to talk about. We're certainly interested in it. And again, we look forward to the questions at the end and maybe some dialogue about what the future may bring. So here's the syllabus for today. We're going to start out with just a real quick look at who's new at the department. And then we're going to more or less march through the regulatory packages that have been either in play or talked about over the last few years and where we think they're going to go. So we're going to talk about the bar defense claim process and the financial responsibility reporting requirements. Then Katie's going to speak to, I mentioned earlier, the accreditation innovation rule, in particular distance ed and state authorization. I'm going to talk a little bit about gainful employment. Remember that old tune? And Title IX, Scott will get into that. And then at the end, Chris is going to give you some thoughts on the legislative front, what's going on with reauthorization and otherwise percolating inside the Beltway. So deep breath. All right, who's new at the department? We're just going to touch on this briefly, but there are a couple of things worth noting. Of course, Miguel Cardona has been nominated as the secretary, Cindy Martin as deputy secretary, both individuals who have, as you would expect, deep experience in and around education. On January 21st, the department also announced sort of its first flight of senior political appointees. Not all of those have to do or have had experience in post-secondary or higher education, but there are 2 or 3 that are notable, and I just wanted to call out, and some of you may know these individuals. Suzanne Goldberg was formerly at Columbia University. She's going to be in that Deputy Assistant Secretary for Strategic Operations and Outreach within the Office for Civil Rights. And as you would expect, this is a person, when she was at Columbia University, she was Executive Vice President for University Life, and before that was involved in the Columbia's Law School's Sexuality and Gender Law Clinic. So a natural fit for the Office of Civil Rights. Ben Miller, a name I think many people will recognize, is going to be serving at least temporarily in a senior advisor to the Chief of Staff role. Of course, Ben was the Vice President of Post-Secondary Ed at the Center for American Progress and previously served at the U.S. Department of Education on the Office of Planning, Evaluation, and Policy Development under the Obama administration. And then Rich Williams, another individual with significant higher ed experience. He was at the Pew Charitable Trust most recently, but before that was at the Consumer Financial Protection Bureau, where he was working on higher education policy and strategy in concert with the White House. One of the things that I just wanted to highlight here, we're going to talk over the next hour or so, about these different regulatory packages and where we think things are going, and we're going to occasionally talk about timelines. But I think it's worth noting, when the Obama administration came in, they had a lot of very bright and talented people who joined that administration, but were fairly new to government positions. So it may have been their first tour in the Department of Ed. And one of the things we're seeing this time around are folks who not only are certainly bright and talented and capable, but this time around have been at the department previously, have gone through rulemaking processes, et cetera. And the reason I highlight that is just to say, it took the Obama administration some period of time to sort of get folks staffed, figure out what their agenda was going to be, and get things moving. Most of the regulatory action we saw from that administration started either near or during the second term. And this time around, we don't expect that type of, we don't expect the administration to need that much time to ramp up, because I think you're going to see more people who have the type of experience and they've been there before and will be able to get things moving more quickly. But while there are some people there, the big note here is that it's still a work in progress. A lot of key post-secondary positions remain unfilled. And here we've just taken a snapshot. The U.S. Department of Ed has a page on its website that it keeps up to date all the time, biographies of senior officials. And you see I've got a little red box down here around where you would see typically the name for the undersecretary. And it's the undersecretary's office and the folks who fill those roles within that office who will really drive a lot of post-secondary education policy in this administration. And many of those positions have yet to be filled. Richard Smith has been delegated those duties, but sort of the permanent folks who are going to fill those positions have yet to be identified. So as of right now, when you're talking about what's really going to be coming down the pipe in terms of post-secondary ed policy, there are going to be key players who have not yet been identified. And we will try to keep you up to date as the months go forward. When we do these presentations, we'll often, I expect, start with something along these lines and let you know if there are new people who've been brought in. Okay, so the first item...
Hey, Aaron, this is Chris. Can I jump in there and add one or two things?
Absolutely. Yeah, please.
Thank you. So to just reinforce Aaron's point, I wouldn't pay too much attention to the Deputy Secretary pick, Cindy Martin. The department is roughly bifurcated in two. One half is the K-12 policy that comes out of the department. That's all under the Deputy Secretary. And the other half is higher ed, which, as Aaron mentioned, goes up to the Undersecretary. So kind of they're both number two positions, and our eyes in the higher ed sector should be more trained on the Undersecretary. But beyond the Department of Ed, I just wanted to add a couple names there. The Domestic Policy Council is a very important body at the White House, also called DPC. So during the Obama administration, DPC was very powerful, and it steered regulation and oversight throughout the federal government. DPC was somewhat dormant during the Trump years, but I expect it to be very active during the Biden administration. And one early signal to that end, to that future activity coming out of DPC, is that Susan Rice, former UN ambassador, former national security advisor, someone who was vetted for the VP slot, is going to be DPC chair. So having someone with her type of profile lead DPC shows how serious the Biden administration is in steering policy through DPC. So a little bit down the chain, below Ambassador Rice, you have Carmel Martin, who is deputy chair of DPC. She has a great Washington title called Deputy Chair for Economic Mobility, only in Washington. I say that with a wink and a smile, truly, because almost anything could be captured underneath her portfolio. But I think it's important for everybody to know that she's a former health committee staffer. She is very well known in education circles and very well respected in education circles in Washington. And so I would expect a lot of education policy that comes through the administration to pass by her desk. And then a recent name that got added to the roster is Kathy Valle. Kathy comes from the Education and Labor Committee in the House. She's a longtime staffer to George Miller and then Bobby Scott, who's now chair of that committee. She was most recently education policy director, but she's really a higher ed person at heart. So she's been promoted up and moved over now to the White House to lead higher ed policy at the White House. So she's going to be an important player to know. She's a great person, and I hope a lot of people who don't know her yet will get to meet her in the next couple of years. And then one last person that I think is just important to mention to be on the radar. Rohit Chopra is going to take over the helm of CFPB. He is very close to Senator Warren. He's been serving as a commissioner to the Federal Trade Commission over the last few years. In the Obama administration, he was the student loan ombudsman at CFPB. So I would expect him to elevate his issues. He cares a lot about student financial aid issues, particularly student loans. So I would definitely expect more action over there at CFPB. And thanks for letting me interrupt there, Aaron.
Oh, absolutely. As Chris and I have known each other for about 20 years, as have a couple of other people on the phone, and they all know that the only way to get a word in edgewise is to interrupt me, because I rarely take a deep breath. So thank you, Chris, as always. Okay, so bar defense and financial responsibility. We've laid out each one of these sections in more or less the same way. And one of our goals here with this presentation was not only to talk about where we think these rules are going to go and sort of the regulatory activity that we think is out there on the horizon, but also to try to marshal some of our existing resources, things we put together, and put them all in one place so that if you all have the slides as you're thinking about these rules and the ones that are recently in effect or about to take effect or that you may want to revisit, all the links and information are sort of in one spot. So that's one of the reasons we designed it this way, and you'll see that as we move through. When we talk about borrower defense, if you've followed me for a long time, you know you've seen this slide before. It's a big rulemaking, and it actually has various components, all of which are pretty darn important. The borrower defense claim framework, of course, is the big one, and we're talking about, you know, what is the process pursuant to which borrowers and schools and the department decide whether or not a borrower should be able to discharge their loans based on something the school did, and whether or not the school should have to pay back those loans. So it's an important topic for students and schools and the department and taxpayers, all of those parties. And some of you know I was one of the negotiated rulemakers the last time that the borrower defense rule in this package was considered. Along with that claim framework, there were also, as part of that rulemaking, pretty important revisions made to the financial responsibility framework, and in particular the introduction of sort of triggers and reporting requirements. Closed school discharge was modified. False certification discharge rules were also modified. And wrapped into all of this was this argument over whether or not institutions should be able to include in contracts with students pre-dispute arbitration agreements and class action waivers. In every one of these sections, we have a rulemaking timeline. We're not going to go through all these line items, but we wanted you to have all of this, and in particular, we wanted you to have all the links in case you want to go back and revisit anything. But you can just see from the first item here, this borrower defense goes all the way back to 1994, and there have essentially been three iterations. There was what was created back in the mid-90s. There was what I'll call BDR2, the iteration that came along under the Obama administration, and all of those things on the prior slide, all of those topics were part of these discussions in 2016 and under the BDR2 framework, and then again for BDR3, so in 2019 when the new rule was negotiated. That new rule, BDR3, became effective July 1st, 2020, so just last year. And again, it made changes to the claim framework and to the financial responsibility triggers and reporting requirements, and also, again, had modifications to the closed school and false certification discharge provisions, among others. So what do we think is the future of this rule? So first of all, revision or removal through subsequent rulemaking, highly likely. Right, highly likely. We think this administration is going to come back and revisit many of these topics. So BDR4, we suspect, is on the way. BDR claims process certainly will be something that we know that they want to look at and will want to revise. And when we talk about the BDR claims process, we're talking about, you know, potentially expanding the bases for a claim. So the Obama administration, for example, said, well, we think a breach of contract or a misrepresentation, you know, or a judicial determination, any of these things could be the bases or be a basis for a BDR claim. And the Trump administration said, no, we think it should just be misrepresentation. So we don't think breach of contract should be in there. We expect that to be revisited. We would expect that there would be efforts to, I'll say, reduce the burden for borrowers. Some might want to say better balance the burdens between the two parties, but at any rate, further adjust what's required for a borrower to successfully pursue a claim. And then one of the sort of things that was really interesting under the BDR2 framework, there was this ability for the department to initiate a group claims process without someone having actually even filed a claim. So in other words, if the department sort of identified a group of schools or a school that it thought had violated the rule, it could actually initiate a discharge process. And the Trump administration said, no, we don't think there should be a group claims process. That's not consistent with the statutory language. We think that'll be back on the table for things that would be reconsidered. Also, certainly the Obama administration's view of the financial responsibility triggers, what should be reported to the department and when, was much broader than the Trump administration. For those of you who may remember, we put out a blog a couple of years ago just sort of waving the flag and saying, hey, under this rule, institutions are going to have to report all their litigation. And things sort of blew up on NACUAnet and elsewhere, and there was all this discussion around whether public institutions and private nonprofits and others would have to supply all their litigation to the department. The answer was yes, under that rule. The Trump administration did away with that obligation, so it could come back. So if this bar defense rule is put back into negotiated rulemaking, one of the things the general counsel's on the phone will want to pay attention to is the discussion around these financial responsibility and reporting requirements, and whether or not all litigation essentially gets proposed again as something that has to be reported. And then we have little doubt that pre-dispute arbitration clauses and class action waivers would again be on the table for discussion. That's assuming there's even still a need for discussion, because the Biden administration has already signaled strongly, and congressional Democrats have signaled strongly, and there's been legislation proposed that would ban at the statutory level pre-dispute arbitration clauses and class action waivers in certain contexts. So, if that happens, the department may not feel the need to regulate or change the regulations in that area, or they might do it anyway just to be consistent with that statute. July 1st, 2023 would likely be the earliest effective date of any new rule. So when the department wants to create new rules that are that relate to the federal student aid programs, or sort of under Title IV of the Higher Education Act, they are required by law to go through negotiated rulemaking. There is no prescribed time frame, but it is typically the case, and I'll just give you a hypothetical. If the department wanted to launch this process, we would expect them to announce it this fall to try to carry out the negotiated rulemaking in the early part of 2022. You'd have to have a proposed rule and a comment period and a final rule that got published prior or on November 1st, 2022, in order for that rule to become effective July 1, 2023. So you can see, even to get the rule to the point of being effective July 1, 2023, this administration is going to have to move pretty quickly. But keep in mind, as we said at the outset, we think they have folks who know how to do that, and we also think they have folks who have been planning an agenda, meaning a regulatory agenda, for some time, right, over the last 3 or 4 years. So it's not as if they're sitting around trying to figure out what they want to do. They most likely already have a pretty good idea. Enforcement activity, likely. So the current administration has a workable framework. I don't think there's any reason they would not enforce the BDR2 or 3. And here's the other thing that's, I don't want to get too into the weeds, but this is an important thing to understand. When the Trump administration created BDR3, they made it very clear that they were not displacing BDR2 entirely. Rather, if the underlying loan in question, in other words, if a borrower is trying to discharge a loan, if that underlying loan were originated and dispersed prior to July 1, 2020, it would essentially be adjudicated using BDR2 standards, right? So what that means is the only loans right now that are out there in the federal portfolio that would be adjudicated under a BDR3 standard are those that were actually originated dispersed for the first time after July 1, 2020, which of course is a very small percentage of outstanding loans. So, the current administration essentially can become active and move forward trying to manage bar defense claims, and most of those claims they can likely process under a BDR2 standard and framework. We also believe this administration is going to increase staffing. There's little doubt they'll be hiring up in FSA. I think that's a pretty good bet. And we anticipate the sort of resurrection of the Student Aid Enforcement Unit. It wasn't dead. It was still out there, but it was quieter over the last 4 years. And that was something that the Obama administration created, and we anticipate the incoming administration is going to be, I guess the arrived administration now, is going to be interested in reviving and strengthening. And at least in its former incarnation, the Student Aid Enforcement Unit included investigations, bar defense claims, administrative appeals, and Clery Act enforcement. What about revision through HEA reauthorization? Chris is going to talk more about HEA reauthorization at the end here, and just sort of more generally about what's going on in D.C. at the legislative level. But we wanted to, in each one of these, sort of get specifically at whether we thought each of these regulatory areas would be addressed in the HEA. And I think borrower defense and some of these other concepts likely would be addressed, maybe not all of them, but some of them we think would be hit on in the context of a reauthorization. We think, and there's been plenty of evidence that congressional Democrats would like to see certain of the BDR2 concepts codified in statute so that the regulations would have to be revised to comport with those sort of the statutory framework and ideas around what borrower defense should look like. Because right now, just to be clear, there's very little in statute. I mean, the statutory language around sort of authorizing and creating borrower defenses is just a few lines. So the whole sort of BDR2 framework and then the whole BDR3 framework are largely a regulatory invention. Congress said go out and create something. So now they could go back and say, look, we thought about it, and this is really what we think this thing should look like. And again, the regulations would have to be revised to comport with that. The other thing, again, is we anticipate that whether it's in the context of HEA or elsewhere, that the congressional Democrats are very interested in revisiting the pre-dispute arbitration and class action waivers, and we think President Biden has an interest in signing that kind of legislation. Finally, the Congressional Review Act. So not possible here, but we wanted to make sure to talk about the CRA with regard to each of these regulatory packages and where they're going. So you all will recall, this is that piece of legislation, the CRA, that permits Congress to enact a resolution of disapproval. In other words, kill a regulation. As long as they can get support from both houses of Congress, and it has to be signed by the President. Congress has to act within 60 days of a final rule being reported to Congress. Now, this notion of when a final rule is reported to Congress is a little wonky, but it's safe to say it's usually in fairly close proximity to when the final rule is published, right? By most calculations that have been done over the last few days, agency rules finalized before August 21st, 2020 would probably not be subject to reversal under the CRA because more than 60 legislative days would have passed. But BDR3 was reported to Congress many, many months before August 21st, 2020. So there really would be no basis. We don't think there would be any possibility of taking a CRA action against BDR3. In case you missed it, hashtag, in case you missed it here, composite score reform. So the outgoing administrator, the Trump administration, initiated a number of efforts to reform and update the composite score. There were composite score revisions that were made in the context of the BDR3 negotiated rulemaking to accommodate FASB changes, and that was around the treatment of operating leases, right, in particular. And those were announced as part, in advance of the negotiated rulemaking. Those were announced as this is going to be part of the neg reg. And then I think it was in the second or third week of neg reg, the department came in. We were all sitting around the table, and the department came in and added this notion of restricting the ability to use long-term debt in the composite score calculation unless it's tied to certain types of activities. And that was sort of a curveball. Some of us felt like that should have been on the agenda, but the department moved forward with that, and it actually became part of the rule. And I know Nakubo and others in higher education had a lot to say about it because how that was going to be managed was going to have a significant impact for a lot of folks in their composite score calculations. There were new interpretations of certain composite score concepts that were advanced in the context of audit resolutions. I don't have any detail here, but I can just tell you we were involved in some of those. So the department was trying to sort of formulate and advance certain interpretations around how certain types of secured debt and things would be treated in the composite score in the context of the audits themselves and sort of working out and enforcing audit determinations and final resolutions. And then there have been plenty of public comments from the department, including the Trump administration, that composite score reform is needed, and if they had had a second term, the understanding is that that would have been on their agenda. Importantly, you know, a lot of this we understand is being driven with support and input from career education staff. So the folks in the case teams and the audit units that spend a lot of time thinking about the composite score. So we think this administration is almost certainly likely to pick that up and move forward with it. Where it would fall in sort of on their list of priorities is hard to say, but I don't think it's too far down. I don't know many people or many schools that I've spoken with who are real happy with the composite score or think that it does a great job. And particularly right now with institutions coming out of 2020 and a lot of folks feeling a lot of stress on their balance sheets, I think composite score treatment will be top of mind. So I think you can expect, even though this level of reform really wasn't part of the Bar Defense negotiated rulemaking, there was the seed of composite score reform there, and I think you will see composite score reform in the years to come, either as a standalone rulemaking or as a significant component of some other planned rulemaking. At the end of each of these sections, we've got what we are calling TC extra credit, the term we've used before, and we just have 2 or 3 things we want to point out for you that are out there in case you want to reference them. One of them, this goes way back. This was a 5-part series we did on the second borrower defense. And you say, well, Aaron, why would you show me a webinar series that's 4 years old? Well, because what we do in these webinars is we go through in great detail what the Obama-era version of the Bar Defense Rule looked like, right, before it was revised by the subsequent administration. And if you want a preview of what may be to come in this space, this version of this rule probably gives you a pretty good idea of where at least some of these Obama-era policy folks who are now coming back to the department, this is where they came from. This was what they put together last time, and I think it's fair to say it's where some of them will at least be starting in their thinking. We also have a webinar, we did or 2, on BDR3, which is in effect right now. So keep in mind, we just said a minute ago, even if the current administration revises this thing, the new version of Bar Defense would almost certainly not come into effect until July 1st, 2023. So you've got some time yet that you've got to comply with the current version of this rule. And in particular the financial responsibility piece. And then finally, if you haven't seen it, we have a financial responsibility reporting guide. So we did one of these when the BDR2 rule was in effect. And you all, the general counsels, folks at institutions, had to report things to the department about litigation and other things, right, under BDR2. Well, as of July 1 of last year, it changed, but there are still reporting requirements. So we updated our reporting guide. So this reporting guide, which you can get at this link, essentially reflects what your reporting obligations are now under the current BDR3 rule, which is the law of the land for now, and we expect will be probably for a couple more years. And with all of that having been said, I will pitch it over to Ms. Wendell. Ms. Wendell, how are you today?
Hi, Aaron. I'm great. Thank you so much. Hi, everyone. I'm happy to be here and walk through what we expect moving forward with the accreditation and innovation rule. Thank you for joining us. So moving right into it, here we see the scope of this rulemaking, which was very broad. They had a lot to cover, as you see here, including recognition of accrediting agencies, faith-based schools' eligibility to participate in the Title IV programs, the Byrd Honor Scholarship Program, new rules for TEACH grants, and the 2 where we've seen the most questions, state authorization of distance education programs and rules for quality and measure of those distance education programs, as well as competency-based education. That brings us to our timeline, which is a great place to easily locate each of these rules and their different versions for reference, as Aaron mentioned earlier. I find it really helpful when I'm looking to verify what the department has said on something. Of course, the department's focus and efforts related to state authorization started well before 2018, but by then, the State Authorization Reciprocity Agreement, also known as NC-SARA, was already in full swing, and the department wanted to promulgate some rules to address that, as well as other things, as you see. Another important note here from this timeline is that in April 2019, the committee actually reached consensus, which obligated the department to then use the draft consensus language as the basis for those proposed rules. As I mentioned, this rulemaking was very broad, so they ended up issuing the new rules in 3 different groups. As you can see, only one set of these rules are currently effective, but the other 2 are set to go into effect on July 1st of this year. So it is important to know what is in them as well, so you can prepare to comply with them too. Now let's talk about what we think the current administration will do with respect to these rules. We understand that there are certain communities that are so focused on this issue of state authorization, but as you know, how important this is to the new administration is all relative. They can't focus their efforts on revising everything at once, so Here we're just giving you our educated guess about how they will prioritize revising or removing these rules. We think it is unlikely that they will make quick efforts at a revision of these rules because they ended in consensus. Of course, it's not impossible, but they will need to be really thoughtful about how they do it because they'll have to defend any changes to the consensus language. Also, we just believe that there are higher priority issues, which my colleagues are discussing today in this presentation, that they will want to address first. If we did see changes to these rules, we expect that they might want to expand the disclosure requirements. There was a more broad approach to these in the Obama era. So although back then they didn't apply to on-ground programs, we do not see them walking that portion back. So we think the professional licensure disclosures would still apply to both online and on-ground programs. We just think they might expand what information is required in those disclosures. Another revision we may see is related to state authorization. After consensus was reached on these rules, there were still some advocacy groups who weren't happy because the final rule prevented states from including additional requirements for subsets of schools, such as out-of-state schools or proprietary schools, within their state authorization requirements because the schools were covered by their NC-SARA participation. Of course, there are some states that have these additional requirements anyway for a subset of schools, and they just aren't tied to state authorization. For example, they may be housed in their consumer protection laws, but it's possible that the Biden administration would want to create a more specific carve-out for these types of additional oversight from states. And I do want to point out that July 1st, 2023 is likely the earliest those changes could even take effect. We do think it is likely that the new administration will enforce these requirements as they have a workable framework in place to do so. Enforcement of the new distance ed laws may be delayed because of COVID-19 waivers and accommodations, however, which I will touch on again in just a moment. We do not see revision through the HEA reauthorization likely for this topic. Again, while these requirements are very important, changing them is not likely to be a high priority for the new administration. We also think it's unlikely that these rules would be included in the Congressional Review Act, though they may fall within the covered period. They were based on consensus from the committee and are probably not a high priority for changes moving forward. So with this, in case you missed it slide, we wanted to call attention again to the distance ed requirements. The new rules that become effective July 1st are pretty serious rules that represent a significant departure from what was previously required. As we all know very well, many schools moved to online programs in 2020 because of the pandemic. Prior to 2020, some post-secondary schools were in 100% online programs, some post-secondary students were in 100% online programs, others took a course or two online. Of course, for most of 2020, most instruction was moved online, which was a big change. But some schools, and for that matter, some students, I guess, found that the change worked well for them. And now that they have it figured out, may maintain more courses online than they did pre-pandemic. They're seeing the benefits of that. So the department has provided a waiver for schools to offer their programs and courses through distance learning without getting approval, and that flexibility has been extended through the end of the payment period that begins after the date on which the federal national emergency for COVID-19 is rescinded. So the department has created this runway for schools that want to continue offering online programs. They will have time to get approvals in place and make sure that their programs comply with all requirements, but something to think about if your school plans to maintain some courses and or programs online that weren't before. So schools also need to understand the distance education requirements that will be in effect starting this July and be prepared to comply with those requirements as well, such as ensuring regular and substantive interaction between online students and their instructors. This is something that even schools who have been offering online programs for years should take a hard look at. So maybe even a good time to go back and look at your agreements with service providers and think through whether your online platforms are satisfying the interaction requirements in those rules. For a deeper look into those requirements, please check out our webinar from last September. We discussed those new distance ed rules in depth. And finally, for anyone who isn't sure if they are complying with the professional licensure disclosure requirements, we did a webinar linked here that you can revisit as well. Of course, if you want to reach out to me via email or phone, I'm happy to answer questions too. So with that, I'm going to turn this back over to Aaron to talk about everyone's favorite topic, gainful employment.
Yeah, and I'll highlight that last webinar we actually did in partnership with DEAC, and certainly appreciate the opportunity to do that. Yeah, so gainful employment. And if you're a private nonprofit or public institution and you're thinking, gosh, this was not something we worried about, I encourage you to continue to gauge here, because gainful employment in this case I'm really using as a proxy for outcomes measurements or some sort of outcomes concept, because I think, we use that phrase gainful employment when we're thinking about the rule that was in place, the first version of it in 11, and then in 2014 the Obama administration, and it was tied specifically to this regulatory language that required programs to lead to gainful employment. But really the bigger picture here is a desire on the part of regulators and legislators to tie federal financial aid eligibility to outcomes and to performance, right? So the gainful employment rule had this debt-to-earnings rate. It had two, really. It had two debt-to-earnings rates. But in both cases, you were comparing debt and or cost taken on by students to get through a program with their income, their earnings at some point after graduation. And there were a lot of challenges with that calculation. I mean, when you really got into the weeds of it, the devil is truly in the details, and it is hard to make something like that work. But the data has gotten better since 2011, and the government systems have gotten better, and folks have been giving a lot of thought as to how to pull data like this together in a way that has fewer issues. This particular rule also included student warning and disclosure concepts, and then certain certifications that institutions with gainful employment programs had to make to the department when looking to get a new one approved. With regard to this particular rule, just to be clear, it was stripped off the books, right? So this was a situation where the Trump administration quite literally just rescinded a prior rule. So that was the 2014 Obama-era gainful employment rule. And in July 1 of 2019, the Trump administration took it off the books. But looking forward, when you talk about what we can expect to see, I think it is highly likely that you are going to see some sort of new outcomes concept. The Trump administration held a negotiated rulemaking to think about creating a new gainful employment rule. And depending on how cynical you are in life, maybe you think that their intent all along was to rescind the old one, or maybe you think they were really trying to come up with something new. The fact of the matter is, though, that the Obama-era concept, again, gainful employment, was it was integrated into the existing regulatory framework in a very specific way. And because of the way it was integrated into the definition of eligible programs, there was really no way to modify it and at the same time have the, quote, gainful employment rule apply more broadly to all programs or more institutions. And because the Trump administration, at least, cited that as a driving consideration, in my view, there was really no way to revise or reform the, quote, gainful employment concept and meet those objectives. But it's important to note that tying outcomes to aid eligibility has bipartisan support. It's not as if the Republicans are disinterested in holding institutions accountable. I mean, that's a very Republican concept. We're giving billions of dollars away, and we want to make sure that, it's someone is being accountable for it, right? And the Republicans have introduced legislation that involves different ideas around accountability. The questions are, what metrics should be used? Is it an, debt-to-income ratio? Is it a repayment rate, right? I mean, there are various different ideas that have been thrown around. How broadly should this apply? The Obama administration was very happy with a construct that largely only applied to proprietary schools because of the way their programs are defined in the regulations. The Republicans have fairly consistently said we would rather see something that applies to all of higher education. And then the question is, whatever you come up with, how do you integrate it into the existing regulatory and statutory framework? This is assuming we didn't have new statutory action from Congress, and I'll get to that on the next slide. But keep in mind, if Congress doesn't say anything new, then that means the department has to figure out a way to create this concept within the existing statutory and regulatory framework and to justify it, right? So that's sort of the starting point, unless we get some sort of assistance from Congress. We anticipate that the incoming administration is going to be very focused on this idea. And I have to tell you, I mean, I was at just as an aside, a presentation a couple of years ago where there were folks from various think tanks speaking. And, you know, a gentleman from the American Enterprise Institute, smart guy, spends a lot of time in higher ed, was very excited about this idea of debt-to-income rates. He wanted better data, and he wanted it applied across all of higher ed, but it just highlighted the point I'm trying to make, that it's not as if there's a lack of interest in conservative parties to have something along these lines. It's about how it's done. But I think there's plenty of support on both sides of the aisle for some sort of concept. So I think there's going to be discussion there and a lot of it. I still think debt to earnings concepts are a likely candidate, whether they are required or tied to gainful employment or some other language or, you know, piece of the regulatory framework is yet to be seen. But I think ultimately the idea would be to obligate institutions to demonstrate some sort of debt to earning ratio. And the feeling is that the data is getting better out there. But also repayment rates have a lot of steam. And, you know, Chris, you may comment on this later if you have a minute, but I know that there have been Republicans who have introduced legislation in recent years in the context of HEA reauthorization or otherwise around the creation of some sort of repayment rate, either as a substitute for core default rates or otherwise. And we saw the Obama administration in the context of its Borrower Defense Rule, BDR2, had a repayment rate obligation that was placed only in that case on proprietary institutions. I think one of the reasons they abandoned that is because it was very difficult for them to justify why that concept should only apply to one sector of higher education. All of this is to say, folks, it's coming. It's coming, and as you are designing programs, as you are thinking, you know, working with the operations and academic folks and financial aid folks, I think it is wise to be mindful of the relationship between debt and earnings of graduates and to be mindful of repayment and outcomes performance, because that's where regulation and legislative activity is heading, right? I mean, folks, these guys love to tie the dollars to performance metrics and outcomes. Enforcement activity, not applicable. There's no existing gainful employment rule to enforce at the moment. Reintroduction through the HEA, I think likely, actually. I mentioned earlier, I think congressional Democrats would like to see outcomes concepts codified, as would the Republicans. The question is whether they would introduce, say, a repayment rate, and the U.S. Department of Ed might introduce a debt to earnings concept, so that you would have two new things introduced, for example. It's also possible, we've seen this in the past, you could have this administration roll out, meaning through the U.S. Department of Ed, new regulations, and then Congress could reauthorize the HEA, and they might have to go back and redo the regulations to conform to the statute. But, you know, so it's hard to know how well Congress and the department will cooperate, but I do think that outcomes are on the way, and that both some sort of debt to incomes measure and repayment rates will be very serious contenders as that conversation moves forward. Congressional Review Act, again, not applicable because there's nothing to rescind at this point. And finally, boy, this is an old standard. So we had not thought much about gainful employment around our office in a long time, candidly. And in the last 6 months, we've had more than a couple of clients reach out and say, hey, do you think you could model for us what our performance would look like if hypothetically we were using the old gainful employment rule? And so we've done that. Certainly if there's anybody out there who wanted us to do that for them, we could. But what you could also do is take out this desk guide that we put together years ago, which is a step-by-step guide concerning how to project gainful employment rates under that old formula. Now, there's no guarantee that any future formula would look anything like this. But it is a debt-to-income formula, and it's the only one and the most recent one that the feds have actually executed on, right, at some point. And so if you wanted to model and just get some sense as to what your programs might look like, you could use this guide to do it. All right. And with that, I will turn it over to Mr. Goldschmidt to talk about Title IX.
All right. Thank you so much, Aaron. And it's sure nice to be here with everyone talking about Title IX. And so the first thing we want to discuss is the new rulemaking, which went into effect last August of 2020. And we'll first remind everyone what we're talking about here. It's Title IX of the Education Amendments of 1972, and that law bans discrimination on the basis of sex for educational institutions. As I said, new rulemaking was instituted that kind of created a sea change in Title IX and Title IX enforcement, and created significant changes. Most importantly, standards were changed for when schools could be held legally responsible for failing to address Title IX harassment and assault. A definition was promulgated to put in place for what counts as sexual harassment under Title IX and what conduct is outside the scope of Title IX. One of the more controversial requirements is direct cross-examination in hearings that was permitted or that was mandated under the rules. And the evidentiary standard was changed from previous iterations or rulemakings, or excuse me, previous guidance that was promulgated. So all is to say, the new rule came out, a lot of changes. We're not going to focus on the scope here, just wanted to give you a little taste. And same thing with the Title IX timeline. This will look familiar to you if you've reviewed our training series, which we'll discuss a little bit later. These slides here are just to provide context. As Aaron and Katie mentioned, each of these hyperlinks are there for you to pull any of the underlying resources. But a couple important things from this slide. So as I noted before, the statute goes back to 1972, and as you'll see, the implementing regulations went into place 3 years after. And following that, there were a couple important Supreme Court decisions that interpret when institutions can be held liable under Title IX and when monetary damages are applicable. But after this, after those Supreme Court decisions in the 90s, we're left here, this next slide, with mostly guidance. And the important thing to note on this slide is what's in that red box. And these are the 3 pieces of guidance that the Obama administration promulgated during their term. And because this is guidance and not a rule, as we'll talk about in a second, one of the first instances of the Trump administration regarding Title IX was to rescind this guidance. And they were able to do that because there was no regulation in place. And after rescinding that guidance, the Trump Department of Education spent a few years developing and promulgating this Title IX regulation. And it's the first one to be promulgated in over 40 years since the regulations that were in place initially in the mid-70s. And this new rule became effective August 14th, 2020, and it is currently the law on the books for institutions that are addressing Title IX sexual harassment. So getting into the future of the final rule, the Biden administration has made no secret, President Biden in the campaign and subsequently, about their dislike for many parts of the rule, specifically the more controversial elements, things like cross-examination and things that the Trump administration put in place for various reasons. But even though there's a lot that the current administration did not like, there's some parts of the rule that they may want to keep. For example, the rule creates a framework for colleges to address and remediate sexual assaults. It has pretty thorough notice provisions and a pretty detailed hearing process. In addition, the fact that the rule itself is created is important. So remember, there was no rule in place for 40 years that addressed these topics. It was done through informal guidance promulgated by the department. So for these reasons, we think that revisions, and likely significant revisions, are highly likely, but it's less likely there'll be an outright rescission of the rule. Similarly, with enforcement activity, I'm sorry, let me go back. So because, again, this is not part of federal student aid, the new rule is not required to go through negotiated rulemaking, and if the Biden administration gets started soon, which is what we assume they'll do, it could be in place as early as 2020. Regarding enforcement activity,
Scott?
Yes.
This is Aaron, too. One
Yes.
other thing, and I apologize for interrupting. I pulled a Chris Murray, so I'm going to start calling that when I interrupt. I'm going to call it a Chris Murray. One of the things we talked about earlier, it didn't show up on the slide, but I thought it was an important note now that I think about it. You know, when the Obama administration was creating its guidance back in 2011 and 2014 and 2016, there was not a lot of case law on the books. And I will say, as this administration moves forward, one of the things that they are going to have to contend with as they revise the existing rule, and we agree 100% on this, I think they are absolutely going to do it. But one of the things they're going to have to contend with is this now substantial body of law that's out there. I mean, there are more than a couple of federal court cases, for example, as Scott, you know well, that talk about cross-examination and the right of an accused to confront their accuser. And, you know, I have no doubt the department's going to go into this with a strong sense of the things they want to change. But I do think it's going to be a little more work for them. I think they're going to have to be very thoughtful about the case law that's out there as they promulgate these regulations in a way that they just didn't have to last time around under the Obama administration because that law wasn't there yet.
That's a great point. And I think just to add to that, there might be things that they want to change that they're prevented from certain court cases. For example, current Sixth Circuit law creates that right of cross-examination, and it's unclear what effect a Biden administration rule could have on that. So yes, I think they might do as much as they can to unwind that, but they just kind of might run into the circuit courts. So that's definitely something great to keep in mind. And then with enforcement activity, again, we think this is highly likely and probably getting started as we're speaking. We certainly expect a significant increase in staffing at OCR, a return to broad-based investigation. So if you remember, the Trump administration's enforcement position was not to take individual OCR complaints generally and turn them into institution-wide compliance reviews. And we might see a return to that. And generally kind of efforts to reinstate some of the Obama principles that were in those rescinded Dear Colleague letters and turn them into either further guidance or part of a new rule. Through the HEA reauthorization, we certainly think this is a highly likely priority for congressional Democrats. They've signaled their desire to carry out Title IX reform as part of this reauthorization, in part so that any changes to the Title IX process are kind of more insulated from the changes in administrations to have that codified in law. And it's unclear whether this is coordinated with the department or it'll just be the Congress kind of going at it alone or some coordinated effort. And last, with the Congressional Review Act, we think this is unlikely for a few reasons. First, as noted above, they're likely got the rule effective early enough that it's not subject to reversal under the CRA. But also one of the important parts of the CRA is it would prevent the current administration from being able to create a rule that's substantially in the same form. And while the Biden administration certainly has its issues with the Title IX rule and regulation, it is our understanding, and they've made this clear, they would like to promulgate their own rule, their own guidance. So the fact that they couldn't put something out in the same form is likely not a great option for them. So in case you missed it slide, state activity. So kind of going along with the court cases that Aaron mentioned, it's critical to make sure you keep in mind state activities. New York, California, Illinois, certain other states have codified laws relating to colleges and sexual harassment on their books. These laws include standards of evidence, training requirements, process requirements, and to the extent that the Trump administration's rule is on the books for a few years, certainly can expect those states and other Democratic-leaning states to take some of the same tacks to try and ameliorate the effects whenever possible. Similarly, once a new Biden rule is drafted or in effect, you see more red states, more conservative states doing the same thing and trying to codify other provisions that they feel that the Biden administration is getting wrong, and so getting into their state laws. So schools have to comply with both federal and state requirements. There was an issue when the new Trump administration guidelines were out about consistency with the two and how that goes, but certainly good to keep in mind and track. Our extra credit, we did, Aaron and I, with a few of our Thompson Coburn colleagues, did a 6-part training series on Title IX, each about an hour long, that really delved into the new rule and how to comply. And we certainly would think if you're interested in learning more about the rule or training requirements, to take a look at that. And last, we also have certain compliance materials about the new rule. I want to do a self-audit of kind of making sure you get the important provisions. We have those all set up. And with that, I'll turn it over to Chris for HEA authorization.
Chris, before you start, let me just add too on the Title IX training series, that's available on YouTube, and it's totally free. And the idea was, under the new rule, for those of you familiar with this new rule will know this well, but in case you're not so familiar, institutions under the new Title IX rule are required to not only engage in a fair amount of very specific training for the individuals that will be helping to carry out their Title IX process, but they also are required to post all of that training on their external websites. So just to be clear, one of the reasons we created that series is it's designed to serve as training for the people in your institution who are going to be responsible for assisting and administering your Title IX process. And as we say on the YouTube website and in the videos themselves, you are very welcome to post those to your external website and at least in partial satisfaction. Satisfaction, that is not the right word. Satisfaction of the requirement under the law. So I just want to be clear. It certainly, if you're just trying to learn about the rule, it's a great place to go. But those were specifically designed to help satisfy that regulatory training requirement. So please feel free to check those out at your discretion. And with that, Chris, again, I apologize for butting in. What's going on with HEA reauthorization, sir? How are things in the Beltway? Quiet, I assume?
No. Well, first of all, Aaron, pulling a Chris Murray, meaning interrupting people, I'm going to take with pride as a native New Yorker. I have a lot of, alive and dead relatives that are proud that I'm interrupting people. So my little bit here, I'm going to focus a little more on politics than policy. Because we're not deep into the policy part of the year on Capitol Hill yet. So we're still in the early stages in the Biden administration building out its team, as Aaron and I talked about before. And we're also relatively early in the formation stage for Congress. So, for example, we don't know the full committee memberships in the House or Senate yet. We know some people that have moved here or there. In the House, we roughly know who chairs of committees and subcommittees will be, but we don't have the full slate of who's going to be slotting in where. So they're still in the formation stage, really, in Congress. But what really interests me vis-a-vis HEA is the Senate. So as I believe everyone on this call should know, the Senate is going to be 50-50 in composition. So with Vice President Harris also holding the title as President of the Senate, this means that the Senate is going to be marginally Democratic. So with the 50-50 Senate, and this is something I think the press is really messing up and not talking enough about in terms of, Democratic control of Congress. Leaders Schumer and McConnell are going to have to come up with a power-sharing deal to run the Senate day to day. So the last time we had a 50-50 Senate was 2001, where leaders Lott and Daschle agreed to a power-sharing agreement where committees were split up 50-50. So the Health Committee and the Appropriations Committee would be 50% Republican, 50% Democrat. There would be no majority, as were committee budgets, which is very meaningful in terms of staffing behind the scenes for committees. Normally, if you're in control, for example, if there were 51 Democrats or Republicans, the majority party would get 2/3 of the budget. The minority party would get 1/3 of the budget. So it is very meaningful for the operation of the Senate. Also, the minority leader in the 2001 deal, which was then Daschle and now McConnell, had some ability to bring legislation to the floor, which is certainly not the case if there's a clear majority in the Senate. So it still remains to be seen whether Schumer and McConnell are going to come to the same deal or change that deal to modernize it in some way. There have been rumors all week that a deal might be coming soon, and we certainly hope that it does for the orderly operation of the Senate. So why did I get so much into this civics lesson? Why is this so important? Senator Murray is going to take over the chair position atop the Senate Health Committee. And so she will likely, just assuming something similar to the 2001 power sharing deal, have a committee that is split 50-50 Democratic, Republican members on that committee. As many people know, Murray and Alexander, Alexander was the former chair of the Health Committee, they made significant headway in negotiating an HEA compromise bill last year before the pandemic derailed the work. They really were making some good progress in February and March of last year. And then, their plans on, having a potential markup got sidetracked by the pandemic and never really got resuscitated to get Alexander his long-sought HEA reauthorization. And now Murray, who is so deep in those negotiations, and her team are leading the effort this time. So to move forward on HEA, and HEA we expect will be the top or one of the top legislative priorities for the Health Committee, Murray needs to build off her work with Alexander and find a way to get a couple Republican votes on her HEA bill. On the Health Committee, at least as it's currently composed, you have several diehard conservatives, but you also have a few members like Mitt Romney, Susan Collins, and Lisa Murkowski, all three of which could be very open to working with Chair Murray of the committee, and assuming all three of them stay on the committee, and only one of them Murray needs to get her HEA bill to clear the committee. So if Murray is somehow able to work with one, two, or three of them, make them happy enough with their HEA bill to proceed, the bill clears this Health Committee and goes to the Senate floor. So it seems totally within the realm of possibility that could happen, and she is more than a capable legislator, one of the best in the Senate. And I'm not saying that in any partisan way. She's awfully talented in terms of her long history of legislating. So she has every ability to get this done. An important item to note is we still don't know who's going to be the top Republican on the committee who's going to replace Alexander. This goes back to the power sharing deal that is elusive for right this moment, but hopefully is forthcoming soon. The lead Republican might be Senator Burr from North Carolina. It could be Rand Paul from Kentucky. We don't quite yet know. But we should know quickly after that power sharing deal comes into view who the top Republican is going to be and how the committee will be composed. So in the House, Ed Labor Chair Scott's team has already worked on two prior iterations of their HEA reauthorization bill, aim higher from 2 Congresses ago, and most recently in the prior Congress, the College Affordability Act. So I would expect Chair Scott to move quickly on his CAA bill and have it clear his committee sometime this year. I would not be surprised if there's some modifications to that bill to align with the work that the administration is doing on regulations. But if I were interested in seeing where HEA was going on a lot of the policies that we've discussed today, I would take a close look at the College Affordability Act as being very, very stable base text from which to jump off of for negotiations in this Congress. So, the big question is, will HEA happen? We don't know yet. It's too early. But it feels like Murray will be very motivated to move on HEA, and certainly I think she's going to be more motivated as chair than any of the Republicans would have been as ranking member, because no one on that committee really had the interest in HEA that Lamar Alexander did, and I just think she is more likely with a Democratic majority, even if it's marginal, to want to move forward than if we had a 51-49 Republican majority. I think HEA would be a little more elusive in that case. So we might get there. It's been 13 years since the HEOA in 2008. Everything remains to be seen. So in terms of a couple policy items, I think we've gotten into lots of good details today on items like gainful employment and borrower defense to repayment, making their way into a Democratic bill as they are in the College Affordability Act. And just keep in mind, even if the department was way down the process of redoing regulations like gainful employment, borrower defense to repayment, and Title IX, if HEA were to pass, the department would then likely have to re-regulate much of their agenda to align with the new law. So that does provide a little bit of a wrench in the gears over at the department, where they might have to start from scratch on some items. So there will likely be a good deal of coordination among the Democrats between the two branches of government, so that they're not stepping on each other. One item I just wanted to note that I really don't think is getting enough attention is student loans. So we've talked a lot about student loan forgiveness. That was in a lot of the Democrats' platforms as they ran for president in 2020. President Biden has said that he wants to do kind of mass student loan forgiveness, but he has deferred to Congress on that item. But just to go back in history a little bit, so when HEOA was passed in 2008, about 80% of the federal student loan portfolio was privately held FFEL loans, and about 20% of the portfolio were direct loans. Well, in the reconciliation bill that got the Affordable Care Act, also known as Obamacare, across the finish line in March of 2010, one of the budget maneuvers that was used to help pay for the Affordable Care Act was switching the loan program over to 100% direct loans. So we have effectively made the Department of Ed, and more specifically federal student aid, one of the biggest banks in the world, with $1.5 trillion worth of assets on their books. And we haven't really done a robust kicking of the tires in this entire intervening period in terms of oversight and legislation of what that actually means in terms of authorization of the primary law that governs this, the HEA. So there's some major structural issues with how all of this works. And I certainly would expect or hope that there would be some focus in the drastically different student loan environment that we're in 2021 than we were in 2008. A couple last notes here. I would just caution everybody to remember how fluid the situation is in Washington in terms of political power. So Congress is very, very marginal, as I've said a couple times now. So it's a 50-50 Senate. The Republicans gained a whole lot of seats in the House, so it's a very small majority for Speaker Pelosi in the House. Moderates are going to have an awful lot of power in both chambers. And just one thing, it's macabre, but it popped in my mind earlier this week. Some of you might have seen that Senator Leahy from Vermont was unexpectedly hospitalized earlier this week. We certainly wish him the best, but that made me think of Jim Jeffords, who was a senator in the 2001 period, who switched parties, became a Democrat, and that gave Democrats control of the Senate, in the wake of the last power sharing deal. I think I have my history right. I'd have to look that back more precisely. But it's just important to keep in mind that if one Senate Democrat were to leave Congress and in a state like Vermont that has a Republican governor, we could very easily get to 51 Republicans in the Senate, and you would have a whole new governing majority. Similarly, an inverse could happen. You could have a Democrat leave the Senate who comes from a Republican state, and it could go the other way. I think I said that right, but you know what I mean. It could go either way. The Senate is marginal at best, and anything could change at any moment. And then one last macro level thing that a lot of people who are on this webinar have heard me say probably for years at a time. As you look back to all of these rules that got promulgated, and more specifically Title IX, that, as Scott pointed out, was run through guidance for so long. We've got various layers in the U.S. system of kind of what holds the most power. So you've got the Constitution, you've got statute, you've got regulation, you've got sub-regulatory guidance. If you want your legacy to be durable in Washington, you have to get it passed into law. We've seen that with the Obama years. We've seen it with the Trump years. It's awfully easy for a president to come in, tear up an agenda, the executive orders, and re-regulate via the regulatory process. So if you want things to last in Washington, you have to do the difficult work of getting Congress to pass laws. So if we get to a point where there are massive changes in items like Title IX, borrower defense to repayment, and gainful employment, and those are done via statute, we're going to be living with them for a long, long time. Aaron, back to you.
Hey, thanks so much, Chris. And I'm just going to, this is just a quick slide on the history of the HEA if you guys want to check that out at some point. And then I will note we got a key resource. If you want to know more about the Higher Education Act, we talk about it at length, and a guy like Chris just knows it. I mean, it's just, it's in your bones. But it may not be so self-evident to everyone. And the Congressional Research Service does a really nice primer that they keep updated periodically, and it gives a really nice overview of the HEA and what it's about. So there's a link to it here if you're interested. And Chris, thank you for your comments. I mean, they're just always deeply appreciated and so spot on. And folks have heard me say more than once, the folks in our higher education practice, we live and breathe by the changes in these regulations. That's what we do for a living. But we also deeply appreciate that it's not great for the regulated community. The pendulum swings are costly. Most of, I'll say all of our clients, the folks I've worked with over the years, really just want to comply and get back to educating students. And when things change and change dramatically every 2 or 3 years, and you spend lots of time, money, and effort coming into compliance with a system that then gets ditched only in time for you to spend a lot of money, time, and resources coming into compliance with a new system, that's just money getting wasted. So I am hopeful that all these folks inside the Beltway will move in a direction of more lasting regulatory frameworks, or at least doing things in a more deliberate way so that the pendulum doesn't swing so far and so rapidly. That's probably wishful thinking on my part, but for our clients, I'm certainly hopeful that will be the case. Additional resources. We've got our blog. Please check it out. A lot of the things we've cited throughout this webinar, we often will debut on our blog when they first become available. So if you want to subscribe, you're certainly welcome to do it. We've been talking about HERF. You can see HERF 2 there. We had a blog recently about it right after it came out. And again, all these webinars, we've got them on all these different slides. But if you want to go to one place and find them all, here's where they're located. They're in our TCLE library, and this actually has the webinars for our entire firm. And just quickly, by way of example, if you look in the middle here on the top row, we've got a webinar coming up on February 4th where some folks in our cybersecurity practice who work a lot with higher ed and actually have been working with the U.S. Department of Ed are going to talk about CMMC and some other issues in that area. And that's not even part of our higher ed webinar series. It's just an offering out of one of our other groups that happens to be focused on an issue that's relevant to our higher ed clients. So if you happen to go to this TCLE, to the grid, where all the webinars are located, you may actually find some other things that are of interest to you. And with that, we will move to questions. And as we had hoped, we have a number of them. And the good news is we got 10, 15 minutes to start thinking through some of them. Let's see. So here's a great question. Doesn't the college scorecard already include information like repayment rates and median debt? And then I love this. I just have to, it says, apologies, I'm not a lawyer. That's okay. You are certainly forgiven and applauded, no less. Yeah, it's a great question, right? So we've got this repayment rate. And what's interesting is when the bar defense to repayment 2 rule came along, and the Obama administration introduced a repayment rate for proprietary schools. At that point, I think it was the 4th repayment rate that was being calculated. And the point I'm making here is the fact that there are already repayment rates out there in use, and being calculated, really, in my experience, will have very little impact on whether or not, say, congressional, folks on the Help Committee, Republicans and Democrats alike, decide we're going to ditch the court default rate and we're going to introduce a new repayment rate of some sort, and it's going to be a new key metric and eligibility is going to be tied to it, right? I mean, and they could come up with something completely new, or they could repurpose some existing repayment rate. I will say, as an aside, the critical question in conversations around repayment rates, and if you are involved in these conversations, if you are talking with folks at, NACUBO or NICU or ACE or wherever about repayment rates, here's the issue I'd ask you to focus on. What is the treatment of loans that are in a state of negative amortization? So most repayment rates, what I mean by that is most repayment rates that have been introduced, there's always a question, do you get credit if the principal isn't being paid down at all? And as you all know, during the Obama administration, the Department of Ed started promoting widely income-based repayment plans. So you've got folks who are on department-sponsored repayment plans, but who are nonetheless not repaying down their principal at all. Well, some of these repayment rates that have been proposed would not count a borrower as in repayment if they don't pay down at least $1 on their principal in a 12-month period. So what that means is, theoretically, you could have an institution that, say, has a 5% core default rate, 5% of students in default, right? You've got 50% of your students that are just on standard repayment plans, and 45% that are on a government-sponsored, backed, income-based repayment plan, but not paying down at least $1 principal a year, and none of those will qualify as in repayment. So your payment rate might be 55%. So this is a big deal, right? And how those repayment rates are structured, remember, the devil's in the details, right? And whether these students who are on income-based repayment plans and not paying down principal are counted as in repayment is a critical question. And so be aware of that. Be aware that you could have different repayment rates that are being tossed around in Congress or by the department, and they could be totally apart from what's being calculated on the college scorecard, and they may end up being tied to student aid eligibility. So, again, devil's in the details. Great question. Let's see. Anybody else, by the way, I don't mean to, any other comments from Chris or others on repayment rates? Chris, I know that repayment rates have been floated in Congress in legislation by both Republicans and Democrats in recent years.
Yeah, but you've also, it's been called many different things. It was called skin in the game for a long time to get institutional skin in the game. I will tell you, there seems to be a major blockage and stumbling block in Congress about legislating this and how it would all actually work. A senior architect of HEA reauthorization conversations in the prior Congress shared, in a small group setting, some things that they had been thinking about in their draft of reauthorization. And it was not only incredibly complicated, but it seemed like a ton of time would be spent by the regulated institutions, to comply with that. I think there's a lot of interest, but there's a lot of confusion on how you would actually do it.
Yeah, I agree. It's just like gainful employment and the bar defense claim process. These are really complicated concepts that require, the gathering and crunching of so much data, and there are just so many challenges, even if conceptually you're completely on board with the notion of outcomes, and performance being tied to eligibility. Actually putting it in writing and making it work is very difficult, and that's what we've seen in recent years. Couple of questions here that I'll pair together. One is, could GE, gainful employment, something like that, be accomplished through executive order? And the other is there any likelihood that a new administration could determine that the prior administration did not have the authority to rescind GE? I'll just answer both of these with a no as a general matter. I mean, they could always try, but I don't think that's in the cards, because the department, And also, I should say, third parties outside the government could and have sued the department regularly over whether or not whatever it tried to do violated the Administrative Procedures Act. And that was true during the Obama administration, and that's been true, was true during the Trump administration. I'm not sure they had a regulatory package they put out that was not subject to federal lawsuit. I mean, it seemed like everything they did, they got sued over. Rightly or wrongly. I mean, there was just a lot of litigation. So certainly someone could sue and make that claim. But the Trump administration did make an effort, and I don't know that they always got there, but they did make an effort. Title IX is a great example of this, and I think gainful employment's a good example, to do it the old-fashioned way. And that goes to Chris's point earlier of, understanding that if you do things through executive order and enforcement activity and sub-regulatory guidance, that's all easily undone. And I think there was some realization, at least within the Department of Ed, under the Trump administration, that if they wanted things to have more permanency, they needed to do them, they needed to create regulations, and they needed to do them in a way that was consistent with the law, which is why, even though they just rescinded gainful employment, they still did it pursuant to a negotiated rulemaking. So what an incoming administration would have to do, I mean, it would have to demonstrate, I mean, they'd have to, and I don't know why they would do this themselves, but what a third party or someone filing a suit or challenging the law would have to do is to suggest that that negotiated rulemaking process for some reason didn't stand up to the Administrative Procedures Act, or otherwise, was flawed, and so the law shouldn't stand, or the rescission shouldn't stand. And I think that's an extremely tall order and would require so much time and resources, and I don't even know if it'd be successful. I think they're just much more likely to say, let's just create our own rule and get the ball rolling and do something that they like. Similarly, executive orders have been used more generously in recent years. More and more, I think, as Congress has been locked up, frustrated executives have been trying to use executive orders to advance their agendas. But I think putting something into place like a gainful employment system is way outside of what can be accomplished through an executive order, which is why you haven't seen it before. But they're great questions, right? I mean, there's this, because we are moving in that direction, as I said, of the executive branch trying to get things done without having to go through the Administrative Procedures Act or get a cue from Congress. Chris, thoughts on that? I mean, I think the department's going to go through a rulemaking. I mean, that just makes sense to me, or work with Congress to get something done in statute.
100%. And not to repeat myself, but I will, if I was the new president coming in, I would be reading my history books of FDR and particularly LBJ, because so much of the agenda that LBJ got through, including HEA and ESEA and civil rights and Medicare, was done with an exhausted Congress. That's actually when they started putting in these long recesses that were mandatory, because Johnson was exhausting them so much. But look how durable that legacy turns if you actually get it written into law. So I couldn't agree with you more. I think they're going to make the best effort to get as much done as they can, just as the prior administration did in regulation, and also coordinate with Congress to see how much they can get done there as well.
And to that point, somebody asked here, what would it do to the timeline if some sort of outcomes concept, gainful employment or otherwise, were created within HEA reauthorization? Well, I mean, theoretically, if the HEA were reauthorized this year, I don't know if that's possible, but theoretically, I mean, it becomes the law of the land as soon as Congress says it's the law of the land. But Congress rarely creates the kind of detail that allows a program to just spring into existence and run. I mean, they're going to provide outline, and they're going to direct the department to do X, Y, or Z, and then the department's still going to have to figure it out. So I doubt that Congress deciding to advance some sort of concept through reauthorization would speed things up a whole lot. I think almost anything that they would come up with, I think the department's still going to have a role in figuring out the details and rolling it out and implementing it, and that's going to take a significant amount of time. So let's switch over. I've got a Title IX question here, and I want to ask Scott. So someone says, well, you've said a lot about Title IX, so what do we do for now with regard to Title IX? We get this question all the time. What do you think?
And it Yeah, no, it is a great question, and I appreciate the chance to talk about it. But I mean, bottom line is the current rule passed in August of 2020 is the rule in effect. So past August 14th, institutions should be complying with that rule. And as we said, like in all the pieces of the presentation, a new rulemaking will take a significant amount of time to get off the ground. So we can assume it will be a few years until we have a potential new rule to go by. So any effort or all the effort that hopefully institutions are taking to comply is not wasted effort. And also important to know that any Biden administration sub-regulatory guidance will, A, can't change the basic tenets of the rule, and B, your institution could still be sued in federal court based on the actual regulation. So institutions should hopefully already be or on their way to compliance with the current rule, and just keep your eye out for current changes or upcoming changes.
And Scott, I think we have time for one more. I don't want to let you off the hook here. Although I do, before that, someone asked here, they said, last year Aaron talked a lot about LSU football. Can we expect to hear more about their most recent season? And I'll just say LSU did not play this past year. Actually, they took this year off. So just if you were thinking they did, they won the national championship, and then they've been taking a gap year. So here's one more Title IX question for you, Scott. In thinking about case law and the new option, and this is complicated, so I'll read it slow. In thinking about case law and the new option to pick between evidentiary standards under the current rule, right? So you could choose preponderance, you could choose clear and convincing, right? Has there been consideration about the fact, and I'm not sure consideration by who, courts, the department, do we think the new administration, about the fact that utilizing a higher evidentiary standard, I assume like clear and convincing, could result in more lawsuits, since preponderance of the evidence is the typical standard in civil courts. Did you track that? I can read it one more time.
I did. Well, let me try, and then I might ask you to weigh in as well, because it is a great question, and it's new because institutions are recently only able to make this decision. 2 points initially. So discretion is limited both by state statute. So if you're in the state of New York, you don't have discretion because state law says you have to choose preponderance. As well, if you have whatever your standard is for any sexual harassment case. So the rule says if you have a clear and convincing or preponderance standard for sexual harassment for employees, you have to have the same standard in your Title IX legislation. But assuming those don't apply to you, I'm not familiar with any additional risk or case law with regard to choosing a higher standard. I will say that all the schools that I'm familiar with and our clients are going with the preponderance standard, so the clear and convincing might be a little bit of an outlier. But the federal law, I mean, the preamble and the regulations make it very clear. If you have the discretion to make a choice, it's kind of up to your institutional values and the way you want to enforce Title IX. It's not whether you believe one standard is supporting respondents or complainants. It's just that how high do you want the burden to be in order to prove your case? So I'm not familiar with that. But I guess it could be an interesting argument to make. Aaron, do you have any thoughts on that? I agree,
no, I'll just add that I know a lot of folks out there are concerned about institutions using potentially a higher standard, and here, the comment is sort of getting at this notion that it could create this potential legal quirk is not the right word, but odd legal outcome. But I will echo what you said, Scott, and I hope the folks out there who may be listening who feel that preponderance of the evidence is an appropriate standard will take some comfort in hearing from us that, like Scott, I'm really not aware of many institutions. I can't think of a one in our client pool, but my gut is that very few institutions are going to use clear and convincing. I just think the vast majority put preponderance of the evidence in place. During the Obama era, I think most of them are going to stick with it and or have to stick with it because they've either got a state issue or they manage their employee complaints already under preponderance of the evidence, so they have to use the same standard. But I really don't. I think that institutions using clear and convincing will probably be outliers. I don't know that. I mean, I haven't done a systematic or scientific survey, but that certainly is my anecdotal conclusion. All right, so I think, we're out of time. I hope folks enjoyed the session. Please fill out those surveys. Let us know what you think, if there's more you'd like to hear about in the future. Here's our disclaimer, just saying that we're not your attorneys. And don't forget our upcoming webinars in the coming months. Like I mentioned, we've got one next month, I think, around M&A and higher ed that folks who are interested in that topic will find really interesting and enjoy. Otherwise, be safe, be well, and we'll see you next time. Bye, everybody.